This is Earl White, real estate attorney. This is a video about use and occupancy agreements in real estate contracts. It is going to cover what is a use and occupancy agreement, when are the common scenarios where a use and occupancy agreement is utilized, and what are the key elements in drafting and agreeing to a use and occupancy agreement. So first, what is a use and occupancy agreement? A use and occupancy agreement can be defined as an agreement between a buyer and seller in a real estate transaction whereby the seller remains at the property, at the premises, following the closing. The seller is deemed a licensee and not a tenant to avoid the implication of tenant's rights, and the seller has specific obligations to the buyer, which are negotiable, but which may include a per diem payment, financial and responsible for utilities, responsibility for damages, and penalties should the seller overstay at the property. Second, what are the common scenarios where the parties will utilize a use and occupancy agreement as part of the real estate transaction? The most common scenario is when the seller needs more time to relocate. Basically, they either need the money from the closing or just time to be able to locate a new residence. So that's the most common situation. It may also come up in other scenarios. For example, the buyer's rate lock could be expiring. The buyer has applied for a mortgage. Rate locks are only good for 45, 60 days. And that rate lock period is expiring, and the buyer will incur costs or perhaps lose the mortgage entirely if it's been delayed long enough if a use and occupancy agreement isn't reached for the seller to remain at the property. And the use and occupancy may also come up to simplify a double closing. A double closing I'll define as when a seller is selling their property and then utilizing the sale proceeds to, in the very short order, like day or two, buy a property and move into it. Now, that can be very complicated because there's two elements here. One is the moving process. So the seller has to move from their property to the new property. Two is the transfer of funds. Since the seller needs the proceeds from their first sale to complete their buy, they have to get the money. But it's not always that simple. So it can be very stressful for the seller to receive a payment and then in the same day take that money and transfer to the buyer side of the transaction when you only have 8 business hours to complete the transaction. Much easier to do a closing on one day, give the time the sale proceeds to hit, confirm the closing is concluded, and then close the next day or the third day in a more orderly fashion as opposed to a long use and occupancy, so it can make the closing easier. And lastly, if the seller has belongings, you could do a limited use and occupancy agreement where it's not for residing, but just for the seller's belongings to remain at the property. So for a limited purpose, if the seller can't get rid of all the belongings, they can have a short period where the belongings can stay. Third, what are the key elements in drafting a use and occupancy agreement? The first and most important element is the duration of a use and occupancy agreement. The buyer and seller, the considerations may be flexible. If the buyer doesn't need to move in, they may prefer a use and occupancy agreement because maybe they'll be getting a payment when the property would have been otherwise sitting vacant. The seller, on the typical maximum period is for finance transactions is 60 days because usually the residential mortgage will require the buyer to move in 60 days. That's usually the max duration. Now, the other consideration in the length of time is how soon can the buyer need to move in. If the buyer needs to move in 2 weeks, then probably a long-term use and occupancy agreement isn't going to work. The second key element of the use and occupancy agreement is the security deposit. Now, you have a security deposit is amount that the seller will put into either a title company or an attorney escrow account at the closing, which could be used to encourage the seller to comply with the terms of the use and occupancy agreement, because if they want their security deposit back, similar to a lease transaction, they must abide by the terms of the use and occupancy agreement or potentially suffer penalties, the money out of the escrow. So typically you'll set that escrow higher, maybe by 50% higher than what you would anticipate the seller needing, because that will give them serious incentive to comply with the use and occupancy agreement. Next is the per diem payment. Obviously, it's very important to the parties how much the buyer is going to be compensated. Seller would prefer the compensation be less. Buyer would prefer the compensation be more. How is it going to be calculated? I've seen it occur in many different ways. I've seen if there's realtors on the transaction, I've seen the realtors present to the attorneys a specific number. That could be based on market value. That could have already just been based on general negotiations. Or it could be free if the use and occupancy agreement, no per diem payment, if the use and occupancy agreement was critical to the buyer's offer, you're outshining other buyers' offers. Now, the elements of the payment, so the number is negotiable. In terms of the elements, the typical payment is to cover some portion of buyers' holding costs for the property. The holding costs can be broken down into the property taxes, the property insurance, mortgage principal, mortgage interest. If there's other unique scenarios such as homeowner association fees, purchase mortgage insurance, that could be implicated in terms of how much it's costing the buyer to hold the property. Obviously, buyer would like most of those categories to be covered. Seller, they want to limit it to just taxes and not cover the buyer's mortgage interest or not cover the buyer's mortgage principal because they're earning equity on that. It's not really a cost per se. They're just coming even. But on the other hand, the buyer may say, look, now I have to pay full rent at this other location where I am residing, if that's the case. So regardless of the principal payments, they're incurring double just to keep this going. So per diem payment is super important. Another key element here is access rights. So if it's a long use and occupancy agreement, the buyer may want to have the rights to be able to enter the property. And that could be a few reasons. One, to check to make sure the seller is honoring, making sure that the property is being maintained. But oftentimes the buyer may want access to the property if they're going to be conducting renovations post-closing. They don't want the entire process delayed 60 days if it goes that far. The buyer may want to, not so much to have the seller leave, but have the right to have their contractors enter the premises in order to begin measurements. So once the seller vacates, the work can commence as opposed to being delayed much longer. Besides, it related to access as keys. Buyers obviously would like to have some kind of keys at the property to access it. Sellers may not feel safe with that because if they're sleeping there with our kids, they may say, look, this use and occupancy agreement, I don't want people having the right to access. I just want to move out in peace and continue to reside in peace without interference from the buyer. So those are some competing considerations on the access and keys. Another key provision here is responsibility for damage. For the buyer, you would want as much damage covered by the seller as possible. So you might propose any property damage at the property is responsibility of the seller as long as they are in possession of the premises. Now that might be a bit unfair to the seller because certain things can happen. Obviously, if the seller is negligent or specifically damages something, they should be responsible for that. However, sometimes damages might be no one's fault. Let's say the central air conditioning, for example, was 20 years old and it was going to break either way. And you could say it's in the winter and somehow it gets turned on and it just doesn't work. Now, the seller has not done anything wrong. If there was no use and occupancy agreement, the buyer will be in the same position. They would turn it on and it would break. The seller could make the argument as part of drafting it that if a mechanical system or a structural system breaks without any negligence of the seller, simply due to the age, they don't have to replace the system. Because even if they did, the buyer is going to be the one that benefits for that system over the long term. So if I was a seller's attorney, I would try to limit the damage to the property to things that were not the responsibility of the seller causing, not upgrades or improvements of systems that were going to break either way. Next one is beyond property damage is what's going to be the penalty for the seller for overstaying. A lot of buyers are highly concerned about what if they stay past the deadline because they have to move in. Because the buyer will need to move in either because the 60 days for their mortgage or simply their other housing has run out and now they need to move in. So what is going to be the consequence if the seller overstays? Oftentimes, attorneys, or if I'm on the buyer side, I will push for double the use and occupancy per diem. So if the use and occupancy per diem is $150, then perhaps it's $300. The point is the amount of the per diem. So once the seller overstays, the amount of the per diem should be punitive to the seller, where it is not attractive to stay, where they are going to burn through their escrow that they had, and that is going to motivate them to comply with vacating, because whatever housing option they have should be more affordable by a significant margin than the penalty they're going to get by overstaying at the property. Similarly, as the penalty, the contract should have if the buyer incurs attorney fees in order to eject. It's not an eviction because they're not tenants, as mentioned. So in order to have an ejectment, and they have a successful ejectment to get rid of it, the seller should be obligated to pay the buyer's attorney's fees. This will further give the seller motivation to honor the agreement to vacate, because if they don't and it has to go to court, not only are they going to get removed from the property, and not only are they going to pay a heightened per diem by failing, they are also going to cover the buyer's attorney's fees. So in that scenario, they'll be highly motivated to vacate the property.